these are messages that make you want to jump in and click and see what's there. So these phishing attempts are often trying to mimic well-known brands, usually for financial gain. One statistic is that there's been a 670% spike in phishing emails from the end of February to late March. Spear phishing is a related problem. It's the use of spoofed emails to persuade people within an organization to reveal their usernames or passwords or deliver malware. It's small scale and very targeted. Malware is malicious link and attachment, so it's often linked to spoofed COVID-19 websites. These fake coronavirus spam sites try to induce individuals to click on links. What would happen, of course, is you would download malicious software. Recently, there was an email supposedly from the World Health Organization. It actually contained a small HTML file that directed users to a spoofed Microsoft Outlook login page. Excuse me. Breaches often happen through a security failure at a supply chain partner, and they might be 3 or 4 steps removed from your own organization. No matter how good your own network security is, excuse me just a moment, right, no matter how good your own network security is, someone else may have worse, bad security, worse security. So if you're relying upon a vendor and they are hacked or they're subject to a ransomware attack and your data is accessible, you're going to suffer a breach even though you have good security. And a good example is Blackbaud. I don't know if you've heard about it. It was a very big breach that happened recently. Blackbaud provides a variety of data services and software to the nonprofit community. A ransomware attack on Blackbaud in May of 2020 saw attackers take control of the company's servers and encrypt some sets of data. They demanded payment for the destruction of the stolen material. Blackbaud paid a ransom to the hacker in exchange for a promise that the copy of data that they had removed had been destroyed. This ransomware is really the malware of choice for hackers because it pays the best and there's a very low barrier to entry. So it's an effective way of shutting down companies and extorting funds. Newer versions such as Maze ransomware are focusing on exfiltrating or removing data with a further demand for payment. And that's what Blackbaud did. Blackbaud said, not only have we encrypted your data, but we have taken copies of your data and we're going to disclose it publicly unless you pay us. And they did. They did pay. They didn't disclose publicly. So far, the Blackbaud incident has affected hundreds of organizations, from healthcare providers to universities and charities. And the breach victim tally has climbed to nearly 3 million healthcare connected entities and other nonprofits. In fact, on September 14, Christiana Care announced that they will be notifying more than 26,000 patients and others about Blackbaud's security breach. Blackbaud told Christiana Care that the hacker may have acquired backup copies of databases. Going to remote work requires leveraging new technologies and relying more on third-party service providers. So critical precautions include maintaining regular offline backups of data, keeping your software up to date, boosting your employee training, and monitoring your third-party vendors. There are some new reminders of regulations that will affect you if you're subject to a ransomware attack. And it's very important to understand how the payments to ransomware hackers are actually made. This chart refers to convertible virtual currency, and you can think of that as Bitcoin or some similar virtual currency. Processing ransomware payments is typically a multi-step process that involves at least one depository institution and one or more money services business. The preferred payment method of ransomware is CVC, like Bitcoin or some other virtual currency. The victim transmits funds by wire transfer or automated clearinghouse or credit card to a virtual currency exchange to purchase the type and amount of virtual currency specified by the perpetrator. The victim sends the currency, often from a wallet hosted at the exchange, to the perpetrator's designated account or CVC address. The perpetrator then launders the funds through various means, including mixers and tumblers, to convert funds into other virtual currency. Also, smurfing transactions. That's a good word. Smurfing refers to a layering technique in money laundering. It involves breaking down the total amount of funds into smaller amounts to make them harder to track. And this mixing and tumbling that I referred to involves using mechanisms to break the connection between the address sending the virtual currency and the address receiving the virtual currency. Companies that provide protection and mitigation services to victims of ransomware and help facilitate payments, which include banks and include various technology service providers, may be engaging in money transmissions, requiring them to register as a money service business with the U.S. Department of Treasury. And they're subject to obligations, including filing suspicious action reports. On October 1 of 2020, OFAC, which is the Office of Foreign Assets Control, part of the U.S. Department of Treasury, warned that companies that make or facilitate ransomware payments to threat actors who are sanctioned persons or to sanctioned jurisdictions risk violating OFAC regulations and related laws. In other words, if you pay a ransom to a hacker and that ransom and that hacker happens to be on an OFAC list of sanctioned individuals, or that hacker happens to live in a country that is a sanctioned jurisdiction, you as the victim of ransomware could face civil, monetary, and administrative penalties of the greater of $300,000 or twice the value of the transaction for every violation. You could also face criminal liability for a knowing violation. Now, this is not a new law, but it is a reminder of the law that exists, and the purpose of these notices were to signal increased regulatory enforcement and put companies on notice of the risk. And so what do you do with this information? Well, first, and this is very difficult to know how to do, you need to take reasonable steps to determine the identity of the threat actor demanding the ransom. And you need to engage early with law enforcement and cooperate with law enforcement. That's considered a mitigating factor, that if it turns out you've paid money to a sanctioned person, it could mitigate your damages. Also, you should implement a risk-based compliance program specifically focusing on mitigating the risk that a ransom payment may involve a sanctioned individual or a sanctioned jurisdiction. Our modern electronic age means that we're all moving around with a number of signatures. We send and receive signals all the time from all of our devices. Every piece of evidence is a fragment, but when they're added together, they could pose a significant risk to security. There's one famous case that happened very recently highlighting the location of secret military bases and patterns of military activity. Militaries and other organizations require constant training of their personnel to ensure and to ensure that they're aware of cyber threats from modern geolocation technology. In this world dominated by the rise of social media, the growing availability of satellites and drones, and increasing use of smartphones, we have an entirely new mentality. So this San Francisco-based company, Strava, provides a fitness tracker app. It uses a mobile phone's GPS to track the subscriber's exercise activity. It uses this collected data, as well as that from other fitness devices such as Fitbit and Jawbone, to enable people to check out their own performances and compare them with others. Strava published a global heat map, and what you're seeing is part of that, of user activity that displays 1 billion activities, including running and cycling routines undertaken by exercise enthusiasts wearing Fitbit or other wearable fitness trackers. It appears to, and of course, who exercises more than military personnel? So this data appears to show the structure of foreign military bases in countries including Syria and Afghanistan as soldiers move around. Major security problem. Although the location of some military bases is generally well known and satellite imagery can show the outline of buildings, these heat maps show where people are moving around. Where are the patrols going? It displays the level of activity. It also appears that the location data has been tracked outside of bases, which may show commonly used exercise routes or patrol roads. So naturally, the military cracked down on their personnel using fitness trackers, but this is just an example of the danger that comes with this geolocation technology. Social engineering has been the tool of hackers on Twitter, on Zoom. Recently, the most crucial moment in the worst hack in Twitter's history sounded like something that you would find unremarkable. It was a call last July from the IT department. Everybody's gotten a call from the IT department. In fact, there was a Twitter person who got a call from the Twitter IT department, but it wasn't. It was a call from a Florida teenager who convinced this Twitter employee that he was a coworker. And this persuasion ultimately granted this 17-year-old access to a host of Twitter accounts, including Barack Obama, Elon Musk, and Kanye West. In March, Twitter ordered all of its employees to work from home, and this created the ideal environment for the kind of attack that this teenager allegedly specialized in. Once inside Twitter, he gained the ability to bypass the company's security protections, and that set the stage for this hours-long hack on July 15 that captivated the world's attention. And it held hostage this entire tool. I think Twitter went down entirely during that period. The other problem, of course, we have is with our Zoom calls. U.S. businesses are turning to these new services to allow their employees and customers to communicate remotely, even as we're doing now on WebEx. The tools include Zoom, Skype, WebEx, Microsoft Teams, and others. There's a massive amount of sensitive and personal information being transferred. So there are protective measures that businesses should take to minimize their privacy and security risk. These include taking steps to ensure that only invited participants are able to join your meeting. You should password protect and use unique IDs for each participant. Take advantage of other tools to limit access to the meetings. Lock the meeting once participants have arrived and approve participants trying to join. Remove individual users. Have the ability to remove individual users. Be aware of whether your camera is on and your microphone is on by default. And consider muting yourself or turning off your camera when it's not needed. You can check to see if the video conference is being recorded, and be careful about sharing your screen. You don't know what else might be on your screen. Don't open unexpected video conference invitations or click on links to video conference invitations unless you know they're coming, because malicious actors can mimic these invitations to install malware on your computer. If confidentiality is crucial, consider not using video conferencing, or use an enterprise solution that has greater security. Review the key provisions of the service's privacy policy to understand how your information will be handled. Make sure they're not saving copies of your transmissions, and update your software so you take advantage of the latest security improvements. ClearView AI. How many of you have heard of ClearView? It's a tiny company that devised a groundbreaking facial recognition app. Sounds good. You take a picture of somebody, upload it, and you get to see public photos of that person, along with links to where those photos have appeared. The system's backbone is a database of more than 3 billion images that ClearView claims to have scraped from Facebook, YouTube, Venmo, and millions of other websites. It goes far beyond anything ever constructed by the US government or Silicon Valley. But without any public scrutiny, more than 600 law enforcement agencies have started using ClearView in the past year. So what could possibly go wrong? ClearView has also licensed its app to at least a handful of companies to use for security purposes. Now, you might think, well, how dangerous is it to me that somebody has my face? But it's the collective that creates a danger, and it's a surveillance danger. Imagine the use of that database with augmented reality glasses. In fact, ClearView has computer code in its app already allowing for its use with augmented reality glasses. So users would potentially be able to identify every person they saw walking down the street. This tool could identify activists at a protest, or an attractive stranger on the subway, or people who are lining up to vote, and would tell the person using the software everything about that person. This app carries an extra risk because law enforcement agencies are uploading sensitive photos to the servers and have no ability to track what's happening to that information. So there's been a lot of scrutiny of ClearView AI. As efforts mount to keep track of people affected by COVID-19, and concern mounts about how protesters are being monitored at protests, and it might be BLM protests or election protests, the push for limitations or bans on facial recognition software is increasing. There are a number of cities that have actually banned the use by their police departments of facial recognition technology. San Francisco was the first. Other cities have joined, including Oakland and Berkeley in California, and Boston, Cambridge, and Somerville in Massachusetts. Tech giants Microsoft, Amazon, and IBM also have enacted one-year moratoria on police using their facial surveillance products. New York State Legislature has put a moratorium on the use of facial recognition in schools across the state until 2022. So the law is struggling to keep up with these changes of technology. There are things that businesses should be doing to protect the privacy of their data. They should ensure that employees use company devices and not their own, that access company networks using, and that they access company networks using secured virtual private networks or VPNs. Use multi-factor authentication for access to company networks. Promptly deploy all required security patches and updates to critical enterprise software. Implement current antivirus or anti-malware software on the networks. Legacy software is a significant risk also because they lack up-to-date versions that patch security holes. Use software that scans emails for malicious links. Limit access to sensitive documents and prohibit downloading of confidential documents onto personal devices. Require strong passwords that are different from home accounts. And provide cybersecurity training and reinforce internal policies through periodic testing. I just got a phishing email this morning that was a phishing test sent by my IT department. I had alerted my IT director, and he said, yep, that was a phishing test. So another day I didn't fail. There are a number of legislative developments we've seen. 2020 has been a busy year so far in cybersecurity and privacy. The most highly anticipated event was the deadline for companies to comply with the California Consumer Privacy Law, known as the CCPA. We've seen thorny data collection issues prompted by an unprecedented global pandemic. And on top of that, we witnessed the demise of the Privacy Shield, which is a popular transatlantic data transfer mechanism. We'll talk more about these items shortly. The coronavirus pandemic has unfortunately stalled momentum at both the state and federal levels to put more restrictions or more clarity on how companies use and sell personal information. It shut down legislatures and diverted attention away from the issue. Washington, for example, was posed to follow California's lead this year with a comprehensive consumer privacy law placing tighter restrictions on companies' use of data. But for the second year in a row, it got shot down. The CCPA is the first law in the US to give consumers the ability to find out what data companies hold about them, to have the information deleted, and to opt out of the sale of this data. You might think with California in the name, you don't need to worry about it, but this law is broadly applicable to businesses regardless of the location that collect or control personal information about California residents. There are some size thresholds, but they are lower than people think. And so companies, even small mom and pop stores, can easily find themselves subject to CCPA. Its effective date was January 1 of 2020. Businesses have been struggling with the compliance challenges of this new law, such as how to verify access requests, how to determine the value of the personal information they collect, which data transfers qualify as sales, and what the sale opt-out mechanisms should look like on their website. California's Attorney General sought to address some of these issues through regulation. There were drafts issued 3 times, and the regulations weren't finalized until June 1. Remember, this law went into effect January 1. Even these regulations failed to provide all the answers that the business community was seeking, leaving room for interpretation on many different issues. This uncertainty is frustrating for a lot of companies, requiring a lot of resources to monitor the moving target of compliance. Enforcement by the Attorney General started July 1st. The Attorney General refused to extend the enforcement date due to COVID. Already, they've sent warning letters to many companies, giving them 30 days to remedy alleged violations. One of the risks of CCPA for companies is that it includes a private cause of action with statutory damages for data breach harm and high fines for noncompliance. And so if you suffer a data breach, California customers who are impacted can bring a lawsuit, and if the data breach happened because of lack of reasonable security, they're entitled to up to $750 per person, regardless of whether they were actually damaged by the breach. This can be very expensive as soon as you have 10 or 20,000 people that are that have this claim. The problems with the CCPA are that it's a very badly worded statute. It was rammed through in record time because of the risk that it would be passed as a ballot initiative. California has a ballot initiative law that allows, with enough signatures, for a proposed law to be put on the ballot and voted on by the population. And any statute which is passed by a ballot procedure cannot be changed by the legislature, except according to the terms of that law. So it's a very risky proposition. It puts laws on the books that can't be changed, regardless of their problems. CCPA compliance costs in California alone cost the economy $55 billion in 2018. And few Californians have benefited from the law. CCPA gives consumers various rights, but most consumers don't even know about them, haven't taken advantage of them. So the bottom line is, in the midst of COVID, the CCPA is forcing businesses to spend money and provide rights that most consumers don't necessarily want and won't use. The key components of the CCPA are expanded consumer rights, and those rights are listed here. Also, it requires that businesses provide consumers with notice of collection and use of data at or before the point of collection. So when the data is collected, even if the data is collected by your third-party vendor, you have an obligation to make sure that the data subject has received the proper notification, which includes a list of all the categories of information being collected, the purpose of the collection, and a link to the company's privacy policy. Also, the privacy practices have to be written in a manner that's easy to read, understandable, and accessible to people with handicaps. There are specific privacy notice requirements, things that must be included in the privacy policies. There are requirements for website updates and consumer rights mechanisms. So there needs to be a link on the website. There needs to be toll-free numbers. And vendors and third parties need to have particular contract provisions in place, or else the transfer of information to your vendor, who might be providing your IT services, would be considered a sale of data and could put you in violation of CCPA. There are specific provisions that have to be in your vendor contracts in order to prevent their access to personal data as being considered a sale. As if that weren't bad enough, I don't mean to depress you, but this really is crazy. The California Privacy Rights Act, that's the CPRA, qualified for the November 2020 ballot initiative. It qualified this past June. And so it will be on the ballot next week in California. If it passes, it will replace and significantly expand the privacy protections introduced in the CCPA. So right when the businesses are trying to figure out the CCPA, trying to understand how to comply, spending in California alone $55 billion in compliance, a new ballot initiative comes along that's going to wipe away CCPA and replace it with something more, supposedly more protective of individual privacy. The CPRA, and I'll tell you, it's going to pass. It's highly popular among individuals, even though many businesses have come out against it. So this is something we're going to have to live with. We're going to have to get our arms around it very soon, because if it passes next week, it's going to become effective on January 1 of 2021, which is only months away. It creates new protections regarding sensitive data. It has a new definition of sensitive personal data, which includes a consumer's precise geolocation, racial or ethnic origin, religious or philosophical beliefs, and biometric information. Consumers have the right at any time to limit the use and disclosure of this information. CPRA also limits the sharing of personal information for behavioral advertising purposes, including tracking-based advertising technology. Consumers have the right to opt out not only of the sale, but also the sharing of this personal information. It contains enhanced protection for minors. CPRA will increase fines for violation of the Act, including personal information of children under 16 years of age, to $7,500 per violation. It creates a new agency for dedicated solely to enforcing the privacy laws called the California Privacy Protection Agency, and it will have a broad mandate to investigate and prosecute possible violations. The problems with CPRA are legion. It takes away the power of the legislature to address consumer privacy over time. For example, how do you balance privacy with many other policy considerations? CPRA is going to have to be the perfect solution for the rest of our lives, because once it's passed, the legislature will not have the power to change it. It can only be deleted or overturned by another ballot initiative. The only changes that the legislature can make, according to the law itself, are those that are consistent with and further the purpose and intent of the act. So imagine if they try to amend it, the litigation is going to crop up over whether it furthers the purpose or whether it's contrary to the purpose. It directly contradicts the deal made back in June 2018 when CCPA was passed. That deal was that if the legislature would pass CCPA, instead of it being a ballot initiative, that the proponents of that ballot initiative would be satisfied. Well, right after CCPA is affected, the same people have come forward with CPRA as a new ballot initiative. No one knows how much it's going to cost to comply with this new law. They don't even know the effects of the CCPA. So how will they know what this is going to do? Also, with the special, yes.
I'm sorry, there, someone had a question regarding the CPRA. Does this only apply to California residents?
It only applies, yes, it only applies to California residents. But unless you are a very, very local company and you don't have any California residents in your database, there is a question of whether you can be subject to it. Also, if you're a business that has business partners, you may have vendors, you may have suppliers who are handling data of California residents, and you have access to that data, it can make you subject to this law. So the scope considerations are going to be very significant, and because California is such a significant state, it's making, and it already has made in this country, the California consumer privacy laws as the de facto national standard. And that is the logical segue to talking about, well, what is Congress doing? And I hate to tell you what Congress is doing because they're really not doing the things that they should be doing. The momentum has been building for several years at the federal level to establish a uniform privacy legislation, but it's also stalled. Although Congress may push to regulate a narrower subset of issues like biometric or privacy location data in the coming months, but all sides agree that some sort of national privacy framework would be very helpful for consumers and businesses, both to understand their rights and their obligations, and for businesses to have a single standard. But the big divide in getting federal legislation is whether to give consumers the right to sue over privacy violations. This is called a private right of action, or whether to preempt existing state laws, such as the CCPA and the CPRA. So just to give you two examples, the recent federal data privacy bill called the Data Accountability and Transparency Act of 2020, which is the Data Act, was introduced in June of 2020. And it would grant a private right of action for individuals, and it would not preempt more protective state laws, meaning all of the crazy things happening in California would still be in effect, and companies would still have to comply with those things in addition to the federal law. And it contains many, many requirements banning collection and use of certain information unless specifically allowed by law, banning the use of facial recognition technology, prohibiting the use of personal data to discriminate. It has requirements regarding the use of artificial intelligence to provide new accountability, on and on. Another law was introduced in September called the Safe Data Act. The acronym is way too long to repeat, but the Safe Data Act is the approximation. But it does not have a private right of action, and it preempts state laws, meaning if that law gets passed, then it preempts any law of states that might be more restrictive. So we don't know what's going to happen. But the impact of the California laws and other laws that have passed are that they have required fundamental changes in businesses' data practices and operations, and they restrict the collection, disclosure, and use of personal information. They require transparency regarding data collection, and individuals are given the right to control the use of their personal information. And companies are needing to come to grips with this. In a survey conducted by PricewaterhouseCoopers in late 2019, only 52% of respondents expected their companies to be compliant by January 2020. So you can examine yourself whether your company is compliant with these policies. I mentioned the Privacy Shield briefly. European Union's top court shook up international data transfer landscape on July 16 when it struck down the popular Privacy Shield mechanism because of US government surveillance concerns, and they required companies to more carefully scrutinize the use of other widely used transfer tools, such as the standard contractual clauses. This has had a huge impact on 5,300 companies that currently rely on Privacy Shield, or at that time relied on Privacy Shield, to legally move personal data back and forth across the Atlantic. Many companies just signed up with vendors who said they were Privacy Shield compliant and didn't have any backup plan. And there's no grace period to get into compliance because the court simply said Privacy Shield is invalid. And companies can no longer just put the standard contractual clauses at the end of a vendor contract and receive data from Europe without a second thought. Instead, they have to carefully consider where the transfer data is going and what protections are in place to prevent US intelligence officials and other third parties from accessing it. COVID has raised fresh privacy and security questions regarding geolocation and contact tracing. To help contain the spread of the pandemic, public health officials and employers have turned to measures such as temperature checks, health surveys, and contact tracing. And these are effective public health tools. Contact tracing is an effective tool, but for it to work, users would have to download apps and provide consent. These methods have raised questions about the extent to which they infringe on individuals' privacy rights and what happens to the sensitive health and personal information being collected. The concerns include device tracking to identify and locate users, data breaches, sharing or selling data to third parties, use of that data for purposes other than public health purposes. After all, you need only a few data points to put together to be able to associate a person's identity with his or her location. There have been a number of legislative proposals, both at the state and federal level, to hold companies liable for misusing consumers' health, geolocation, and other personal information, and limit how contact tracing apps can sweep up users' data. So far, there's been no overarching federal privacy law specifically applying to contact tracing. So developers and employers and public health authorities have to consider what other state or federal privacy laws they may be subject to, such as Illinois' Biometric Information Privacy Act, which is one that has potential for stiff statutory penalties. The CCPA also could apply, although confusingly there are carefully defined exceptions, including for medical information or scientific research. There are other state law claims. There could be privacy tort claims or actions under the federal HIPAA law if you're a health provider. The Senate has floated various proposals that would hold companies liable for misusing this information. The CDC has issued guidance on contact tracing. And so technology keeps evolving and changing, and it's recommended that the apps be open source and allow users to delete the data. There are two types of contact tracing apps. One tracks a person's location, and the other tracks the proximity of that person to others. the proximity model is the one used by Apple and Google, and it uses Bluetooth. And Apple and Google have gone so far as to disable apps that use GPS location technology at the same time as using Bluetooth proximity technology, so that you're not able to determine a person's location and proximity at the same time. There's a lot of inaccuracies in this technology. For example, if you're in an urban environment in a skyscraper, it can show you right next to a person who might have been infected, even though you might be 10 floors apart inside the building. So what are we to do with all of this information? Companies should understand what laws, regulations, and guidance apply to your business. Common principles under these laws may be the way to go. That is, consider, is the personal data collection required? Try to anonymize the data that you collect. Collect your data only for specified and explicit purposes. Provide transparent information on the processing activities that you're engaged in. And ensure that you're properly securing your data and you have confidentiality policies in place. Also consider if you can achieve the same thing in less invasive ways. Conduct a risk assessment of internal operations and third-party vendors. Implement robust cybersecurity and privacy policies that are tailored to your risk profile, and develop your needed internal policies and procedures. These can include an information security program, a vendor management program, and an incident response plan. New remote work environments increase the likelihood that companies are going to face privacy incidents. So ensure that your organization has adequate incidents and response plans and that they're updated regularly. Train your employees, just like the phishing email, the training phishing email I got this morning. Make sure you're training them to know how to respond and react. Review your insurance coverage for cyber-related incidents. Instead of trying to reconcile all of these laws, pick a framework and follow it. Make sure you exercise leadership to develop a culture of competence and compliance within your organization. Establish clear roles and responsibilities. Regarding data, identify what personal information you're holding. Know the type of information you're holding, where it's held, who has access to it, with whom it's shared, how it's transferred. Understand its entire life cycle and have policies and procedures in place that take that into account. On the whole, organizations face a difficult set of privacy issues arising from the use of screening processes and technologies to reintroduce workers and students to workplaces and schools during the COVID-19 pandemic. The landscape of legal privacy issues is going to continue to change as CDC guidance changes over time, as more governments pass new legislation to specifically address COVID-19 related challenges. And we'll see what the election brings with the new California law. It's going to be a mess for companies that have worked so hard to comply with CCPA to have an entirely new set of requirements thrust upon them with no consideration as to the economic impact or the balance with other issues. So with that, I thank you for your attendance, and I would welcome any questions, or if you have questions, you can also connect with me later at our sponsor site, and I can follow up with you individually.
Thank you, Bill. I just wanted to, we're wrapping up, remind everybody to check the agenda and check out the vendor sites as well. I believe that there is a question in the chat. Regards to location tracking on a motor vehicle, does this expand past a motor vehicle? Is tracking permitted on a BYOD when associated with an MDM from the employer? And that question is from Ben.
Well, there are several questions there, and there are laws that regulate location tracking on automobiles. That is license plate tracking information. There is a law in Delaware regarding license plate tracking. I know there's a law in California regarding license plate tracking. I don't think, well, the only law that would apply with respect to tracking of personal devices would be generally the laws governing personal information and what you can do with it. And mostly it's the California law that requires notice that you need to let people know what data you're collecting about them, why you're collecting it, and give them the opportunity to see the data that's been collected. So I don't think most apps are doing that, so it raises compliance concerns.
Okay. Any other questions for Bill? No? Okay, all right. Then just to say that there is links at the agenda to each presentation if you have anything. Also, it has all of Bill's contact information as well if you have anything that comes up later on. So thank you again, Bill.
Thank you.
All right. See you, everybody.